Senate President become Vice President if the VP gets impeached? Well, the answer is yes, but not automatically. Under the succession of government, the Senate President is third in line to the presidency. But under the Constitution, a vacancy in the office of the Vice President is settled by the President, who can appoint any member of Congress as Vice President. This is, however, subject to the approval of the members of the Senate and the lower house voting separately. In an interview with the Philippine Star's online show Truth on the Line, Senate President Cheese Escudero said he is not interested in the position. Escudero went on to say that delicadeza dictates that senator judges in the upcoming impeachment trial reject the offer to become Vice President. Escudero also reiterated that he would not give in to pressure to either delay nor fast-track the impeachment proceedings.
If you ask me, I'm not interested, and it would be not good to look at. Kung magpapasa kami laban halimbawa sa kanya, at tapos isa sa amin ang papalit, siguro it would be more prudent for those who voted to, if at all, remove the Vice President, to decline any such offer or nomination.
All right, here to discuss more about the impeachment and the mechanics of it, of Vice President Sara Duterte, is we have attorney Paolo Tamase. He is an assistant professor at the UP College of Law, where he specializes in constitutional law, among others. He is also the author, the primary author of the primer on impeachment. Good evening, welcome to the Big Studio, the Big Story studio.
Thank you for having me.
Yes, thank you so much for coming to our assistance tonight.
Yes. Well, no, but maybe you should answer that question first on the Vice President, the story that Paui just read. It's not automatic that the Senate President or even the House President or House Speaker becomes Vice President should the Vice President get removed from office, right?
Yeah, it's absolutely not. So we don't have an acting Vice President in our system. And what the Constitution provides is if there's a vacancy in the Vice Presidency, the President gets to appoint from the Senate and the House. And I just want to point out that I think Senator Escudero said something about delicadeza in the process. The only time that, from my recollection, we've had a Vice Presidential succession was during Gloria Macapagal-Arroyo's succession to the presidency. And the Vice Presidency was, in fact, filled up by a senator who did participate in the impeachment trial of ERAP, and that was Senator Gingona.
He was also the minority leader, I believe, at that time.
But he wasn't Senate President at that time, you're right.
Yeah, he wasn't. So
he was the minority. He was in the minority at that time.
So the succession of the Senate President only really happens if both the presidency and the Vice Presidency are vacant. So if only one of them is vacant, then the Senate President doesn't actually succeed to that position. And it's a very temporary stopgap measure until a next president can be elected by the people at large. So the Constitution makes contingencies for that situation.
But in this case, he can only choose from the Senate President and the House Speaker?
No, the President can choose from anyone in the Senate or the House.
Okay.
And that choice has to be ratified, confirmed by separate votes in the House and the Senate.
Okay,
This
all
is when
along
we
I
talk
thought
about
it was just the two houses, the two heads of Congress. I thought it was just the two heads of
it
Congress.
was anybody.
Anyone.
Yeah,
Okay.
anyone.
Anyone from Congress, it has to be ratified by both, by majorities in both houses, voting separately. Remember when voting separately became an issue as well. So it's very important to note that.
Yes.
Would that change things, though?
Probably not. Honestly, the decision of the president who to choose as senator or as a vice president in case there will be a vacancy is really a political decision on his part. And typically, at least in the time that it was filled up by Senator Gingona, there seems to have been a support from both the House and the Senate. So there seems to be a lot of deference to the president's decision on who to select as his vice president in this situation.
In this case, from what you can see, he should have a lot of leeway too, right? It's not like people are jockeying to become vice president, right?
Yes, generally. So based on experience, there seems to be, people coalesce around the decision or the choice of the president.
Right. Okay, so we invited you here because you guys hosted a very interesting 3-hour forum last week at the UP campus talking about the impeachment and how it may be carried out. And I'd like to begin by tackling this very same questions that you raised. So if I could just, maybe you could flash the question on the big screen behind us so that everyone can see. So the first question is, can the 19th Congress call a special session and start a trial while in recess? There's been much debate over this. If we could just flash the graphic on the big screen behind us, not full screen, so that we could discuss it whilst the question is up there. But there's been a lot of debate over it, right?
Right.
We've heard from both sides. Where do you and what do you guys think? And in UP College of Law is, of course, the birthplace of a lot of the smartest, largest legal minds in the country.
Wait, but before you answer, Attorney, can we break it down into two parts? Because this question is actually two
you
questions.
Carry over.
Yeah.
So it is
cross
about
over
the
pala.
special session.
Yeah.
I mean, that is also being debated. Can they call a special session for impeachment or not, right? And can they start a trial while in recess, not just pre-trial?
All right. So whether the 19th Congress can call a special session, so there were two sides to this position. I think, on the whole, whether the Congress can be called to a special session by the President. The entire panel that we had, Senator Gilon, Justice Carpio Morales, Commissioner Sarmiento, Professor De Vera, and Professor Ted, they all agreed that the President could call, even if it's not for a legislative purpose.
Oh, okay.
But whether Congress can itself call itself into session, that one isn't really settled. Typically, the Constitution provides that the Senate and the House meet in an agreed schedule for both chambers, and it's the President who calls a special session. But on the second question of whether the Senate can start a trial while it is in a legislative recess, the panel was split there. So you had Commissioner Sarmiento, who is a member of the framers of the 1987 Constitution. He was part of the Constitutional Commission. His view is that, forthwith proceed, which we've talked about in the last time I was here, commands the Senate to meet, even in a recess. The rest of the panel wasn't too hot on that interpretation. I think their point is that forthwith proceed just means start the trial as soon as possible, but that it accounts for special circumstances, such as in this case a recess. And so for them, the Senate has to decide or has to come to trial immediately as soon as the Senate convenes again, but it does not have to do it during recess. So the panel was quite split on that. As for myself, I'm a bit, really in the middle on this. I haven't really formed a position yet. I tend to lean a little bit on Commissioner Sarmiento's side, that forthwith proceed means something in the constitutional text. But I'm also aware of the realities of how difficult it is for the Senate to meet legally while they're still in recess.
But wait, sorry, on the first part, they can call a special session even if it's not a legislative matter? That's in the Constitution?
In the Constitution, it says that the President may call for a special session at any time. And
It doesn't have to be legislative.
Yeah, it doesn't limit.
Qualify.
It doesn't qualify.
About what?
About the reason for it. And Senate President Drilon pointed it out in the forum. Separately, outside of the forum, I think Congressman Colmenares pointed out that the President has in the past called both houses in a special session to hear a foreign leader speak, the Japanese Prime Minister. And so it doesn't have to be for a legislative purpose. But whether Congress can itself call its own special session without the President, that one I think is, not
I wanted
really
to focus
settled.
on that one, Attorney, because as we know, congressional sessions are dictated by the Constitution, right? It basically dictates when you start, when the breaks are, how all of that. So if they convene themselves formally, then they would actually be violating the Constitution, right? Or is that not a black and white thing as well?
Not necessarily. So the Constitution mandates when they have to start and when they have to end. But the breaks in between are purely the practice of the House and the Senate. And in this case, they've decided on this calendar at the beginning of the 19th, I think the beginning of the session last year. So the intermittent breaks are really the call of the House and the Senate deciding together, but the mandatory start and the mandatory end, that's in the Constitution. And we're currently in one of those intermittent breaks.
We're in recess,
Yes,
right?
we're in the middle recess.
Okay, so the jury's still out on that one.
Yeah, definitely.
But also, Prof, I mean, you've got Senate President Cheese Escudero arguing that they are in recess, and that is his argument on why they cannot convene right now as an impeachment court. So at the end of the day, who will decide with finality on what forthwith means, on when exactly they should convene? I mean, what is the jurisdiction also of the Supreme Court there?
I think if you go to the views during the forum, all of us, so I myself, was in agreement that it's the Senate who gets to decide. And the reason why there's a lot of uncertainty around these questions is because the Senate hasn't made a formal official position yet. So Senator Escudero's views is one thing. As the Senate President, he certainly has weight, but the Senate hasn't decided yet on these questions. And the way that the Senate would decide would also trigger the independent judgment of the other branches of government as to whether they will respect the Senate's interpretation of the Constitution or they would have their own. And therefore, really, it's the Senate's first call, and probably the most important verdict might be the Senate's.
That seems to be like my main takeaway after watching the live stream of the UP College of Law Forum. My takeaway was that, I mean, people are right. The ball really is in the Senate's court, and so much of the calls have to be made by the Senate. Would that be a fair assessment?
Yeah, that's a very fair assessment. Although that said, the fact that the ball is with the Senate not right now doesn't mean that people should not be engaging in an intelligent discussion of how to interpret the Constitution. So I think another point I've made before is that the Constitution is the people's document. We get as much a say about this as lawyers do, as senators do, as Supreme Court justices do. And therefore, the forum was really an opportunity to bring out all of these views on these novel questions and let the Senate eventually decide, but hopefully in an informed manner, knowing all of the pros and cons of each argument for what they're about to do.
Actually, I was telling my co-anchors about it. I was telling them about the closing speech of Attorney John Molo, whom you know very well. He said something along the lines of, yes, it is the Senate who will vote, but ultimately it is the people who will decide, who will judge.
Yes.
And which, speaks to your point now. The Senate is very sensitive to what the people are saying.
Definitely. You see that in the Estrada impeachment. So that first impeachment trial in our country's history, you get to see how the Senate was weighing evidence, was looking at the law. Ultimately, it got decided by people on the streets. And, that doesn't have to be the way that every impeachment trial ends, but whether the impeachment court got it right or got it wrong is ultimately tested by people through the ballot, through public participation.
It was also kind of the same with the impeachment of Chief Justice Corona, right? In the beginning, they always say this, in the beginning, only a few senators were in favor. But in the end, there was, of course, a lot of public pressure. And we do know that those that are sitting in Senate right now, they more or less probably are looking at the executive. For a spot at the executive. And having said that, though, how much jurisdiction does the Supreme Court have? Everyone's looking to the Supreme Court to referee, to kind of give some sort of a final word on this. But
we'll save the Supreme Court question for last.
later.
Let's get through the second question.
Okay.
So, now, in the event the impeached resigns before conviction, does the trial get terminated, and will the consequences, or should the consequences apply? That's the second question in your forum. Tell us your takeaways from that.
I'm surprised that in the forum, I think everyone answered that the trial doesn't necessarily have to end. The ball is with the Senate now, and therefore, and Senate President Drilon pointed this out, because the Constitution says that the Senate is the sole judge of impeachment, of trials in impeachment, then it's the Senate who gets to decide when it will end trial. And that follows American precedent. We've talked about it before. And I think I was surprised that everyone on the panel agreed with it, that the Vice President's resignation doesn't necessarily result in the termination of the impeachment trial.
But back here in the Philippines, and the few impeachment trials we've seen, Senate has never chosen to continue with a trial after resignation of the impeachee.
Yes. So I did ask that question to Senate President Drilon. He was a great resource because he's the only person who's really been on both impeachment trials who we could get at the
He
time.
sat through two.
Yeah,
Okay.
both the Estrada and the Corona trials. And I did ask him, why did you decide to terminate the Estrada impeachment then? And his view was that it was a political decision to get the country to heal and come together. And that, again, highlights the political character of impeachment. If the Senate is the sole judge of impeachment contests, then the Senate gets to decide whether it will still continue or not. On the other hand, if you look at all of the other cases where there were impeachment complaints filed but did not proceed to trial at all, Ombudsman Gutierrez, Chairman Andy Bautista, I'm not sure if the complaint was even transmitted to the Senate at that time. But definitely the Senate didn't find it was consequential to continue with trial. And so again, going back to the initial point, there's a lot of respect that's given to the Senate when it comes to this question on deciding whether to push through or not with the trial.
But whether they decide either way, the consequences will apply. There are two penalties, right? There are two
Yes.
consequences. One is
Removal.
from office. Number two is
Permanent
permanent disqualification. As we know, people are more interested in the second one, whether that second consequences will apply.
Yes.
Should she get impeached?
So
Convicted, I mean.
The view of the panel is actually informed by that second consequence. Everyone in the panel mentioned that there were two consequences in impeachment, and therefore there's a reason for the Senate to continue, even if the official resigns. And in this case, if Vice President Duterte resigns, the panel during the forum thought that it gets to decide whether she's fit to hold any public office, even after the vice presidency.
But the bottom line is the Senate gets to decide.
Again, the Senate gets to
Oh,
decide.
okay, so much power.
That was my
You would
takeaway.
think that there's something in the Constitution that says if the person resigns, then you must carry on with the trial to see it through to the end and then, decide from there. You would think there'd be something in the Constitution, but
Well, the Constitution, as worded, we have a pretty long Constitution compared to, let's say, the United States. But it's still a very bare bones document, and it's designed really to adjust to the political and policy realities of the day. And so this is just one of those questions that the Constitution left for Congress, for the Senate, for the House, for us to decide at a particular point.
But it was so important. One important thing, we have been talking about the word forthwith, and apparently it only appears in our Constitution, not in the U.S. Constitution, which our Constitution was patterned off. So I was
so
just
who put that in? Who put in that word?
Maybe Commissioner Sarmiento had
Yeah.
some input.
He talked about it, and I think the feedback was that from Commissioner Sarmiento was that there really was an intent on the part of the Constitutional
framers.
Commission, the framers, to ensure that there would be no undue delay in the trial and in impeachment proceedings. You have to go back to the history of the Marcos era impeachment, where in the first Marcos administration, where there were so many procedural hurdles that Marcos allies were able to use to defeat impeachment complaints during martial law, immediately after martial law. So the framers thought of lowering the required number of votes to convict, lowering the required number of votes to impeach, and probably included forthwith as well in order to tell Congress to speed up the proceeding.
When it comes to forthwith, and going back to, I think we touched on this earlier, some say there's an amount of reasonableness that goes with the as soon as possible message of the word forthwith, right? Meaning the reasonable means the schedule, the predetermined recesses, etc., etc. Because we are divided, people, right, are divided about that. How do you think it's going to fall, honestly? Because it's now up to the Senate gauging, right, Filipinos' reactions, our feelings, and which side we're on, and what we are inclined to pick if we were the senators. I think that's kind of their mindset, and trying to read our minds. Your thoughts?
I think that, in terms of interpreting forthwith, the Senate would be motivated by reasons outside of the law. And that's not unconstitutional or wrong at all. Right? Again, the Constitution gives them a lot of leeway to decide to interpret these provisions. I think on the whole, accountability requires that they move quickly. But there's also a recognition that this is a political process. And therefore, and it's conceded by the speakers of the second panel that we had, who are the counsels for the House and Vice President Duterte, that the people get a say in this proceeding.
Yeah.
So insofar as the Senate is biding its time to gauge public opinion, that might be a valid reason, in my opinion, but there's a limit to that. Because you can never really know public opinion short of an election. And because the Vice President is not up for election, then any result from the upcoming elections would be speculation as to whether it's really driven by support of the Vice President or something else, or the sheer popularity of the candidates.
Yeah, well, Professor, since we're talking about the timeline, let's say this does happen in the 20th Congress, with SP Escudero saying it might be taken up after the SONA in July already, meaning there are already a new set of senators, new Congress members. What's the validity of that? I mean, help us understand, because you've also got some groups saying, some critics saying it's not valid because they'd be having a fresh mandate. The senators will also, you have got new senators elected already, so it's not the same 12 that was in the 19th Congress.
So this was one of the questions that the panel was also split on, because I think they weren't sure about, or nobody's really sure about whether the Senate would still have the authority to continue. So there are two views currently. One view says that the Senate would get to continue because, as Senate President Rilon pointed out, or his view is that the Senate is an independent, the impeachment court transcends the Senate. And therefore it can continue even if the present Senate goes away and a new one is elected in the coming election. I think the other view, and that's really an accountability view, right? The idea that you should hold the vice president accountable and therefore it should transcend the typical end of the term of the Senate. The other view is founded more on a democratic view of the Constitution, in the sense that, or the impeachment process, in the sense that when elections happen in May, that reflects a popular choice to elect different people. And that choice, or the choice of the people who will succeed the current Senate, should not be bound by the past Senate's decisions on whether to proceed to trial or not. So again, the jury is out. And if the question really is, so what's going to happen? It's the Senate again who gets to decide.
So I was going to say, who gets to pick? So it's
I
still
think
the
all
Senate.
the questions will
Yeah.
only be answered by the Senate.
The Senate will throw out the hypothesis, and then it's the rest of the branches of government and political actors will contest that hypothesis. And ultimately, it's the Senate who gets a first crack at this.
Let's
I was
get to the
checking-
third question.
No, before we move there, just one quickly, because this was interesting. I was talking to Attorney Tamase earlier in the holding area, and I asked, okay, so if the 19th Senate moves and they decide on the rules for this impeachment, will the 20th Congress be bound by the rules of the 19th Congress? And his answer was,
No, they can get to decide their own rules. The Senate is not bound by the rules of a previous Senate. Of course, that raises all sorts of questions about, typically...
About the case, like, do you start over?
And
Yes.
does the impeached official, right, is her due process rights violated by that sudden change in rules? So it opens up a lot of questions if it crosses over to June 30.
I told you it was interesting.
Third question in your forum. Is there a standard of evidence in impeachment trials? Should there be? And one thing that I found interesting with this one is apparently the bar is set lower. There doesn't have to be proof beyond reasonable doubt. Talk us through it.
Yeah, so, for the information of all of the viewers, the quantum of evidence is this legal fiction threshold for a judge to decide whether to grant a relief or not, right? So if it meets that threshold, then a case is won or lost based on the judge. But you see how it's so confusing to hear. I'm just saying legal definitions. Imagine a person who is not trained as a judge getting to decide that. So the view of Professor Te, which I think the rest of the panel shared, was that these standards for judges, preponderance of evidence, proof beyond reasonable doubt, to a certain extent probable cause for prosecutors, they're addressed to people who are trained in law and who really deal with these types of questions on a day-to-day. But the impeachment will be decided by people who are not, most of them are not lawyers.
Yes, but the ones arguing will be lawyers. So it kind of confuses me as a non-lawyer, right? So we're saying it's political. We're not going to hold them to the highest quantum of evidence. But then again, there are lawyers arguing for the impeached official. They're lawyers picked for the prosecution panel. And then in the end, the decision could be, not based on law.
Yeah, definitely. So that's just one of the unique features of impeachment, that, while a judge will typically look at law and fact, if you look at the Corona impeachment, if you look at the Estrada impeachment, a lot of the discourse is centered on just the conscience of the judges or the senators who get to decide that case. So you can't put a standard
Yeah.
of proof on conscience.
conscience.
And therefore, a lot of it comes from the fact that these senators were elected by people, were trusted by people to make the right decision, even in cases of impeachment.
I think it was Attorney Te who said this, and I liked this answer so much I wrote it down during the forum. He said, in looking at the evidence, senators should answer the one question: what would convince me that this person should not hold office again, overriding the will of the people who put them there in the first place? Ultimately, and that's what you're saying about the conscience. It doesn't have to be like a criminal case, proof beyond reasonable doubt that they're guilty. It's just, what would convince me that this person should not hold office again?
Yes, and that's not a low bar. That's quite a high bar.
Oh, okay.
Because in order to say, impeachment ultimately overrides the fact that people, in the case of elected officials, that these people were elected by people directly. In the case of Vice President Duterte, 32 million votes or something. The Senate gets to decide that those 32 million votes, that their trust has been broken, and that despite the 32 million votes, she should not be trusted with office anymore. So if judges and senators take their job seriously, the conscience thing is actually harder, because it's easy to say that this didn't meet the quantum of evidence. It's very hard to say, honestly, that from a matter of conscience, this person should not be trusted with public office anymore.
Well, Professor, in the last two impeachment cases, you've got two presiding officers who were both lawyers, Chief Justice Davide and Senate President Juan Ponce Enrile. And now you look at Cheese Escudero, he's also a lawyer. Does that influence how he will preside over this impeachment trial?
It does, in the sense that you can trust that there will be a little more procedure and order than if it were a non-lawyer sitting as Senate President. So, but you can look at it really more of as like basic rules or heuristics, right? Who gets to say first? Who gets to decide these objections? The Estrada and the Corona trials were aided by very competent lawyers. So Senate President Enrile and Chief Justice Davide. Senate President Escudero is also along those lines. He used to be a faculty member of the College of Law as well, so he would probably know the procedure.
So more procedural.
Yeah, it definitely will not be the determinative factor in the impeachment. But in terms of just getting the proceedings orderly, then he would contribute to that.
Okay, we're running out of time, but we still do need to get to the last question, which is what John was asking earlier. If a case is brought to raise these questions, may the Supreme Court step in?
I think there's no question that the Supreme Court would have the authority to step in. No, it would have jurisdiction for whatever grave abuse of discretion the House and the Senate would commit or had committed. But whether it should step in is a different question.
So it's a conscience thing for them too?
Well, not exactly like that, but more of to decide whether these questions should be decided by judges and not by politicians and the people themselves. So that's what we call justiciability, and really the familiar term is the political question. So the courts typically don't decide those questions. They leave it to the political branches to decide. And I think the panel in the impeachment forum was quite split. Of course, Justice Carpio Morales, who wrote a famous decision on this, did say that the court had the discretion to step in. Senate President Duran was more of to the point that the court should stay clear and let the Senate play its role in this impeachment.
I'm going to reiterate a question that Senator Dulon raised during the forum. He did ask, what happens if the Senate does not follow the Supreme Court? Will there be will they be declared in contempt? What are the consequences?
And can they not follow the Supreme Court?
That's exactly what the political question is. So the court tries to avoid that type of determination because it will be forced to reckon with its own legitimacy. What if the Senate doesn't follow the Supreme Court? And that creates a constitutional crisis of sorts. So if the court doesn't feel that it has the moral authority, to put it in those words, to decide this question, then it will probably just step back and let the Senate decide itself.
There were no such issues during the last two impeachment trials that we saw with President Erap and with CJ Corona. Correct me if I'm wrong, but there was no hotly debated Supreme Court, try the last-minute save going on there.
There was one in the Corona impeachment, at least as to the secrecy of the bank accounts.
The US dollar accounts.
Yeah, the dollar account. So that was raised in the Supreme Court. The Supreme Court actually issued the TRO. People forget it now. So, And the Senate decided to respect it, but not without having a procedural vote on it. So that shows that while the court does get to weigh in quite authoritatively on this question, the Senate is not just going to follow the Supreme Court blindly. It's going to look at the decision of the court and decide on its own whether it will respect it or not.
So, kumbaga noted.
Yeah, but in that case, no good.
Sorry, we're fast running out of time. I just have to squeeze in this one question. All along, we've been talking about the impeachment process, but can I take you a step back and look at the process of the initiation of the impeachment complaint? Because that's another issue, and we've heard both sides of it. The last person we spoke to about it was some of the House prosecution panel members, and then they reacted to what Attorney Israelito Torion said. Attorney Torion is part of a group of Mindanaoan lawyers who are asking the Supreme Court to declare null and void the impeachment, saying that it was defective on technical grounds. It did not go through the correct verification process, and it violated the one-year prohibition rule. What are your thoughts on that? Just very quickly, about a minute.
Yeah, I kind of disagree with Attorney Torion's point on this. So, on Dean Torion's point, I think his case was that there were mandatory periods in the Constitution that the Senate, or that the House rather, did not follow. And therefore, that means that all of those prior impeachment complaints should be considered as filed, if I understand the case correctly. But those periods don't really affect the validity of a complaint or the invalidity of a complaint. And ultimately, it seems that the process followed by the House now is the same process that they followed during the Corona impeachment, which was really upheld. And therefore, it might be a difficult thing to argue in court.